I don't care whether it's your intent or not. It has no basis in law at all. You're just filing stuff. I'm not putting up with that. Are we clear on that? You want to represent yourself in this?
Yes, Your Honor.
You don't want help?
No.
Okay. That you are before the court on the charge of resisting and obstructing a police officer. You understand that charge?
I do.
All right. That is a felony or a high court misdemeanor. It is punishable by up to 2 years incarceration and $2,000 fine plus court costs. You understand that?
I do.
All right. You also understand, sir, that there can be great peril in representing yourself.
I understand.
So what do we wish to do today?
I would like to first file a request for suppression of this evidence.
Suppression of what evidence?
Of body cams, squad footage.
On what basis would you be doing that?
Miranda versus Arizona.
Which says what?
That I was not read my rights prior to being detained, and because of that, any violations that I could have possibly said that could impede the faith of my case.
That's your basis?
That I have the right to be read my Miranda rights. I'm not trying to suppress it from the court to see. I don't want it in the public domain.
You're going to have to put more in writing for me to even understand that, because as it stands here right now, based upon what you told me, I'm going to deny your motion.
Miranda rights only apply to custodial interrogation. Body camera footage is just visual evidence. You can't suppress video because you weren't read your rights.
Have you sent a request to the prosecutor's office for discovery?
I have not. No.
Have you asked them, how do I get discovery?
No, I will be doing that.
Do you ask anybody how to get discovery?
I asked a couple of the clerks, but they can't, give too much legal advice.
Okay, well, I'm going to, at this point, deny that motion because there hasn't even been a request for discovery. If you don't get something, then you bring a motion for discovery.
Okay.
Discovery doesn't work that way. First, you request it from the prosecutor. Then, if they don't provide it, you file a motion with the court.
Next thing you want to do?
Discontinue all hearings until there's substantial evidence on file.
Okay, that doesn't happen that way. I don't know what discontinue all hearings mean.
I don't know either, Your Honor. I'm just represent myself over here.
This is going to be a long process if you just are throwing stuff out there.
I tried to prepare my best for this. I'm really
okay. This was your best. Then you may want to consider getting an attorney.
What does the prosecution expect next in this case?
Pardon? What do you mean?
You're asking me for what I want out of this case and what I expect.
I'm asking you, what do you want to do today?
I want to go home and have all charges lifted.
That's not going to happen.
Okay, so
I mean,
what do I got to do?
Going home is an option, but the charges aren't going anywhere. Here's what I'm going to do. I'm going to take a break because I have to have something happen before noon, and then I'll recall your case in the next block. And then maybe between the time I leave this bench and come back, you'll figure out exactly what you want to do.
Yeah, I'll
maybe how to do it.
I'll do that.
Or maybe if you want an attorney to represent you to help you through this process, because otherwise this thing could go south for you.
All right.
Court's in recess. Court recalls case People versus Daniel McGraw.
Pass along to people.
What do you want the court to do?
I want the court to find on what grounds throughout the discovery process that I'm guilty of these crimes.
Okay, sir, it doesn't. You seem to want this process to work away. It doesn't, because I think you know what you're doing, but you don't.
Yeah, a lot of my civil procedures I will be correcting and will not have any more problems with. But as for right now,
your civil procedures,
I'm trying to follow the rules of federal civil procedures, and this is my
federal.
Yeah, this is.
Yeah,
I think so.
Okay, so we're a state court.
Okay,
and this is criminal proceedings.
Then thank you for your guidance.
Yeah, so you might want to start there. It's become readily clear to me you have no idea what you're doing,
right?
And so I'm going to ask you, and it's going to cause some difficulty for you. So I'm going to ask you again, do you wish to be represented by an attorney?
I do not.
Okay. Motion denied.
During recess, Magoo submitted a written motion filled with impossible requests.
Defendant requests the court cancel all current bond conditions pending the
Motion denied.
The request is to continue all scheduled hearings until requested testimony, evidence, and hospital records are provided. So I don't have an issue if the defendant needs more time to be prepared to have a hearing, but I do have an issue if he's trying to say that he can't do anything until we subpoena somebody's medical records. So I'm going to get a search warrant for somebody's medical records and depose officers in a criminal case.
That part of the motion is also denied.
That's all. Thank you, Your Honor.
Okay, so what are we going to do?
I would like a chance to amend the motion.
No, you can file whatever motion you want, but I'm going to tell you something, sir. I'm not going to sit here listening to frivolous motions.
Okay.
I'm just not going to do it.
That's not my intent, Your Honor.
No, I don't care whether it's your intent or not. 3/4, if not 7/8 of that motion that we just dealt with was frivolous. It has no basis in law at all. You're just filing stuff. I'm going to tell you, I'm not putting up with that. Are we clear on that?
We are clear.
So what do you wish to do now? Do you wish to have a preliminary exam set?
Yeah, I'd ask for some for an adjournment in order to review the discovery materials I've produced from my FOIA.
That what?
That I've came up with through my FOIA request. Or I'm going to plan on submitting the procedures as normal through the prosecution too, as well. But I need time to review
What
the
does
documents.
that mean?
That means I just got the documents and I haven't been able to review them, and I need time to review them. Your Honor. I can't decide on something and request for something right now in this moment if I haven't reviewed evidence.
So all you want is an adjournment.
After this response that I submitted to her and she submitted back, yes, sir. Adjournment for pretrial, adjournment for discovery materials.
You know something, sir? Just because you use what seem to be legal words and try to place them into a sentence doesn't mean that it makes sense.
I understand that, Your Honor.
No, I don't think you do. I think you were just placing words in sentences, thinking that because what you're asking for makes no sense. And if you think it does make sense, then maybe this court needs to send you for a competency. And I'm not saying that jokingly. This doesn't make any sense. I'll grant your adjournment. Next time you'll need to fill out a sheet to do it, but I'm not going to waste the time today to do it. All right. Probable cause conference.
The case gets adjourned until December. The prosecutor leaves discovery instructions on a Post-it note since Magoo refuses direct communication. Meanwhile, the judge is left counting down the days until he has to deal with this again.
Yeah, let me at least have some turkey before I have to deal with this again.